Okay.
Hi, everyone. My name is Kim Weber. I'm the Executive Director of the Ethics Commission, and thank you so much for attending our training today. I would like to offer a special hello to all of you higher education people that are attending today. I know there are a lot of you. And with that, we will get started. So today's training is limited to the Ethics Act and the Open Meetings Act, but I'd like you to know that we do some other things here at the Ethics Act, at the Ethics Commission. We help determine who is eligible to serve on county school boards. We interpret a provision of the law that applies only to county officials, and we're going to touch on that today. We administer the Administrative Law Judge Code of Conduct. Lobbyists in West Virginia have to register with our office, and certain people need to file financial disclosure statements with our office every year. Jumping right into the Ethics Act itself, these are the main topics we're going to touch on today. We have using public office for private gain, soliciting and accepting gifts from certain people, prohibited public contracts, trinkets, voting, conflicts, employment restrictions, post-employment restrictions, and some disclosure rules. So the first major provision of the Ethics Act is the do not use your public office for unlawful private gain. And that private gain can be either to yourself or to anyone else. And there's an exception that says that the violation has to be more than de minimis. And the question is, with de minimis, what is de minimis? How many rolls in this illustration, how many rolls of toilet paper is one too many to cross that line? And here's another issue where the de minimis question comes up. And this came to me by way of a phone call. And someone called and said that they noticed that county clerk and her husband over the weekend had used the county's dumpster to throw away roof shingles. And so the question in my mind was, well, you know, it really comes down to, I think, how much garbage was disposed of. If it was just a few shingles, then that probably would be de minimis and would not rise to the level of a violation. But if the whole dumpster was filled, that probably would rise to a level of a violation. There's another exception in the Ethics Act that comes up a lot. That is bonus points earned from business-related travel. And in the Ethics Act, there is a specific allowance that allows you, as public employees and officials, to keep these points. But be on guard. That rule does not apply for non-travel related bonus points. And this is a brand new example I can share with you because it just rose by way of advisory opinion a couple months ago. And in this opinion, someone who works for the state, who coordinates the events and the travel for her office in the state, she asked us whether she could keep the Marriott points that were accumulated when she made the travel arrangements for many people in her office. And the Ethics Commission said that she could not, that was not the intent of the exception in the Act, and that she had to use those bonus points for further state travel. And here's an example of another thing to be on guard about with your bonus points. In this case, someone in the higher education area had responsibility for the P card expenditures for the university in a certain area. It was a sports program. And he, in making these purchases for the state, he accumulated a lot of bonus points. But he used those bonus points for himself and for his family members to get sportswear. And because that was not travel related, that was found to be a violation of the Ethics Act. And somebody filed a complaint against him. And this complaint ended up in a conciliation agreement or a settlement where this college employee admitted that he violated the Ethics Act, and he was issued sanctions by the Ethics Commission. And the sanction to be really leery of, I think, is this idea of a public reprimand. And when that happens, the Ethics Commission gives a press release about a settlement or a conciliation agreement or finding of any violation of the Ethics Act. And so when there is this public reprimand, all the media outlets are notified about it. And another thing to keep in mind is any findings of violations of the Ethics Act, whether it be through a public hearing or conciliation agreement, they are on our website. So they are out there in internet land for anyone to see. Now, here are some more real-life examples from conciliation agreements of violations of the private gain provision of the Ethics Act. The first, mayor had town employees fix water leaks at his house while the public employees were on city time, and use city asphalt to pave his own driveway. Another example is a state agency director stored his personal furniture in the state office building. And another is when public service district employees sold surplus equipment that the PSD had stored outside because it was no longer using it. So they sold it on eBay and split the proceeds. And here's another way that people, public employees or officials, may use their office, their public office, for private gain. And in this case, someone filed a complaint against a circuit clerk. What had happened is local police officers had been called to his house. And when the police officers decided to arrest the circuit clerk said things like, "Don't you know who I am?" And he made some vague threats of retaliation against the police department and these police officers. So again, a complaint was filed, conciliation was reached, and the sanctions you can see on our website. Another brand new advisory opinion is to do with using agency-issued cell phones. And the Ethics Commission said that you should not be allowing employees or officials to use the public cell phones that they get for their jobs unless the public employee is helping to pay for the cost of the phone. So even though everybody these days has a phone and an unlimited plan, and it wouldn't cost the public agency any more to simply allow the employee to use the phone for personal use, that would still be prohibited under the private gain provision of the Ethics Act. So if this arrangement is in your office, make sure the public employees and officials are helping to pay for the phone and plan. And this is also a brand new, this is actually a conciliation agreement that was just reached last month. And in this case, someone filed a complaint against a police officer who used the city-owned phone that he carried for his personal use. And he used the city contact phone number as his personal contact phone number. And in particular for his work as in his private contracting business, and also his private activity of coaching soccer. And finally, he sent inappropriate pictures of himself displaying parts of his anatomy, we'll just say. And I've got a picture up there that I actually used AI to create, and you can see I'm illustrating he's part police officer with his badge, he's part business person representing his business, and of course he's in his underwear. Another area under the private gain provision to be careful about is how you spend public money. And if there's any question about the way you want to spend public money, if you're not sure if it might violate the private gain provision, you should look at the law outside of the Ethics Act. And on my slide there are different places to look to make sure that you're spending public money legally. And typically, when there is an unauthorized expenditure of public funds, the only way the Ethics Act and the Commission are going to be concerned is if there is an unlawful private gain as a result of using the funds in an unauthorized manner. And this is another brand new advisory opinion. And in this, a county clerk asked the Ethics Commission whether she could approve using county funds to pay for elected county officials to attend a conference. This conference was called the West Virginia Leadership Program. And she wanted to make sure that it was okay to use public funds to cover it because it was a pricey event. And what the Ethics Commission said is it's okay to use county funds to cover this as long as there is either implied or express authority to use the funds that way, or if there's an overriding public benefit that justifies paying the county employees or officials attending this function. And also in this advisory opinion, the commission set a standard that is helpful, I think, for those public officials that are responsible for approving others' expenses. And in this case, the commission said that it's okay for the county clerk to approve these expenses when the county official who's doing the traveling believes and states that there is an overriding public benefit for his attendance at the conference, and it's not illegal on its face. So as long as those two conditions are met, that's fine for a county clerk to approve the use of city funds in that way. Now, another area to know about is political activities. And we get lots of questions, of course, at certain times during the year and what have you. And we get a lot of complaints and phone calls about this. And the takeaway to know from all the advisory opinions from the Ethics Commission and the complaints that we've been through is that generally it's okay for public employees to run for political office and even to hold political office with some exceptions, but typically that is what the Ethics Commission has held. Now, there are other laws out there that may prohibit a public employee from holding another or a public office, but those laws are outside of the Ethics Act. One comes to mind to be on guard about for you state employees. Some state employees who fall under the Department of Personnel's jurisdiction are subject to a policy, and this policy says that certain civil service employees may not hold public office and are limited in some of their other political activities. So again, the Ethics Act does not prohibit it, but other laws might. A question came to us this year as well, asking about compensating city employees and whether it would violate the Ethics Act if a city, instead of giving a raise to their city employees, instead gave free garbage pickup to their city employees. And the Ethics Commission looked at the law, found that there is express authority for the city officials to set the compensation of its employees. And therefore, it was authorized however the city wanted to compensate their employees. So if they wanted to do that by way of free trash pickup, that would not violate the Ethics Act's private gain provision. Okay, and here's a little pop quiz question that Mr. Roush, who's on this call today, put together. And I think it's clever and makes our point pretty well. And the question is, does the pursuit of an ill-conceived, foolish, money-wasting project constitute a violation of the Ethics Act? And the answer is maybe, but not necessarily. Although the failure to wisely manage public coffers is a serious matter and may violate lots of laws out there and may cause someone a political election, it doesn't necessarily violate the Ethics Act. And I mention this because we get a lot of calls about officials and people in positions of power in the government, people who don't like the way that money is being spent. And so we get lots of calls. But most of the time, those are policy decisions that are being made by the public official and within the public official's discretion. And it's not something that violates the Ethics Act. So I point that out for that reason. And nepotism, we get plenty of calls about nepotism, and the rule for the Ethics Act is that a public official or employee may not directly supervise or participate in any other employment decisions of a relative or someone who lives with them. So that is what the Ethics Act prohibits. Now, all of you out there, you may be subject to your own policies at your own government agencies, and your nepotism policies might be more strict. So make sure you check both policies and make sure you're following both. Now, under the Ethics Act, these are the people that are considered relatives. And I'll let you read those. I won't read it to you, but you can see that not everyone who you might think is a relative under the nepotism part of the Ethics Act. And here is a recent advisory opinion. This came out in 2024. And in this case, a mother and a daughter were working together in the same public agency, in the same department. And the question is that okay? And of course, if you look at the list of relatives, mother and daughter are relatives. And the Ethics Commission looked at the rule, and the rule, of course, is whether they supervise or hire one another. And they didn't in this scenario. And so the Ethics Commission said, well, it's okay then for them to work in the same office. The test is when one relative's work only tangentially affects the workload of another, then that's fine for relatives to work together in the same office. The Ethics Commission has a guideline for you all to follow. And this is another place where your office, your agency may have a stricter rule. But the Ethics Commission has made a blanket assertion in this guideline saying that it's okay to spend public coffers in the amount of $25 per year per employee for public recognition and retirement events. And I recognize that that threshold is pretty low at $25. But that is what it is at this point in time. And if you are going to have or host such an event, I encourage you to go to our website and read the guideline, because there is some nuance in there that you want to be aware of to make sure you're staying in accordance with our policy. And for retirement events, the guideline provides that it's okay to use public coffers up to $100 in addition to that $25 limit. And the next area to be on guard about is commercial endorsements. Be careful not to make them unless there is an overriding public benefit. So for example, you don't want to make a commercial endorsement. If somebody asks you to give a testimonial, whether it's in writing or on video, and it's going to be used for businesses' marketing materials, make sure you don't do it unless you get confirmation that there is an overriding public benefit to do that. So here's an example. It's an old one. It's from 2013, but I present it today because we have been getting questions about this very topic, and I have been referring people to this advisory opinion. And in it, this came from a public university, and the public university had a memo of understanding with a vendor. And the question was whether they could include in this memo a provision that would allow employees free use of the product, and in exchange, the university would allow the vendor to use the state's logo on its promotional materials. So the Ethics Commission did the analysis, which is done on a case-by-case basis, to see if there is an overriding public benefit. Commission thought that there was, said there is an overriding public benefit, so we're going to allow this under the Ethics Act. However, still, the university should not be making an active endorsement for the vendor, but it was okay to use the university's logo. And we've had 2 new advisory opinions from earlier this year on this provision of the Ethics Act, which is soliciting subordinates for business is prohibited. And in this case, a Board of Education member could not hire a school bus driver that worked in the system to transport him on his off hours. So the and you can see my little example there, that's from Dumb and Dumber. And the commission considered whether the school board member was a supervisor of the bus driver and concluded that yes, that was the case. And next, whether it was business that the Board of Education member was soliciting from the employee. And the commission again said yes. So therefore, the answer was no. The school board member could not ask the subordinate bus driver to work for him off hours. And then down in the corner on that slide, you can see the second brand new case on this provision. It was very similar, also in a Board of Education context. Now, having said that, there are explicit exceptions to the prohibition. And I'll let you look at those on your own. The one that comes to mind to me is if a supervisor who's the public official advertises to the general public, or if the subordinate goes to the supervisor's business, like the storefront, for example, or the site or the website, then that's okay if the subordinate goes there on his own initiative and does business with the supervisor. Confidential information, we government employees and officials often have access to it. Be careful how you use it. You already know there are a host of privacy laws out there, and the Ethics Act just adds another one telling you not to disclose it improperly. This is an example of a violation. We haven't seen a lot of violations of this provision, but this is one. A deputy was running against the incumbent sheriff for sheriff, and the sheriff in his campaign used the fact that the deputy had submitted sick leave that was not proper. The sheriff came to believe that rather than being sick, the deputy was on vacation at the beach. And because this was to do with medical information and a doctor's excuse, that was exposing confidential information for his own private gain in violation of the Ethics Act. Now we're leaving private gain, and now we're going to talk about what is acceptable gift and what is acceptable in soliciting donations. The general gift rule is a public servant should not accept a gift valued at over $25 from certain people, not everybody, but certain people. And the list is there in bullets there. Lobbyists, state officials should not be accepting gifts valued at over $25 from a lobbyist. People at all levels of government should not be accepting gifts from someone who is a vendor to your agency or someone who wants to be a vendor of your agency. Also, should not accept gifts from someone who is regulated or controlled by your agency, or someone who has a specific financial interest in you doing or not doing your public duties. Classic example, this was back from the 90s. University procurement officer should not have accepted 2 free NFL tickets from a university vendor. And there are some exceptions to the $25 limit. And the first is the meals and beverages exception. And that comes into play if for example, a vendor or yeah, a vendor takes a public servant out to lunch, and it's okay for the vendor to spend more than $25 for that lunch on that employee. Also, gifts that are purely private do not fall under the prohibited gifts rule. So if, for example, you are offered a gift from a vendor, but you've been friends with this vendor for a long time, you've been exchanging Christmas presents with this vendor long before you had this relationship, this professional relationship, that's going to be seen as purely private in nature and not prohibited by the Ethics Act. And the next area to be on guard about is soliciting donations. Public officials should not be soliciting money in general, unless it is for a charitable purpose. Now, what is a charitable purpose? For purposes of this provision, the ethics for that, the Ethics Commission has a brochure. And in this brochure, it outlines all of the 75 times that the commission has taken this question up in advisory opinions. It's a very short, if you can believe it, two-page chart that in a few words lists what purposes have been deemed charitable and what purposes have not. So that's a brochure. It's on our website. I always encourage everyone to go to our website. We have all of our brochures, all of our advisory opinions indexed and summarized. It's a great resource. Please use it. Also, feel free to reach out to anyone here at the Ethics Commission. We have a staff of 5. We have 3 of us are attorneys. So we answer questions all day long by email, by phone. And we've been doing this for quite a while, most of us. So we pride ourselves in being able to answer questions really quickly. And we've had some brand new advisory opinions this year on what constitutes charitable solicitations. I'll mention these just briefly. A city police department, it was found, may not seek donations to fund a firearms training facility. That was found to not be a charitable purpose and therefore not okay to ask for donations for. But the commission also made clear that it is okay for public officials and employees to do things like sell advertising to help fund these projects. So, for example, it would be okay to sell a plaque, for lack of a better words. And if there was going to be, let's say, a hall of sponsors dedicated in a public place, recognizing these people or businesses for making donations, then that would be okay, even if the use of the funds was not for a charitable purpose. We do have a provision saying don't use public officials' names on things that are bought with public funds. And also in the law is a provision that says don't name public buildings after public officials who are currently in office. The next area of the Ethics Act to watch for is prohibited contracts. And the general rule is that public servants may not have a financial interest in contracts under their authority or control. Good example is a city's contract for a new backhoe is seen as a contract under the direct authority of each of the city council members and the mayor. Therefore, it would be prohibited. And it also, such a contract would be prohibited because it's under the control of some other people lower in the administrative chain. For example, my example here is a laborer. If a laborer who works on roads tells her supervisor that they need a new backhoe to do projects, she is actually seen as having some control over that contract. And she then, and her family, may not have a financial interest in selling the backhoe. And there are some exceptions I will let you see here. The biggest and non-intuitive one to me is public employment. So at the city level, for example, a city council member, although the city council member may not have a contract with the city, he can work for the city. And I know that's hard for me to get my head wrapped around, but it's just because there is a specific exception in the Act that allows that. Now, I mentioned at the very beginning that we offer advice. We do not enforce, however, a provision that applies only to county officials, and it prohibits even more contracts than does the Ethics Act. And basically, it applies to high-ranking county officials, county commissioners, their board members. A lot of people in the county school system are also subject to this. And basically, I'm not going to go through it all, but if you find yourself in this situation, you do want to look at this. We have brochures about it. We have 50 cases or advisory opinions on it. Or cut yourself a break and call us or send us an email, and we will guide you through this prohibited contract provision. But a very recent advisory opinion that might be a good illustration to help you remember it. The Ethics Commission said that a county farmland protection board member could not participate in a farmland program. That's because the board would pay him for a conservation easement across his land. So the board member had control over the contract, and the board member had a financial interest in it, and so it was a prohibited contract. And I've mentioned two different ways that contracts can be prohibited under the law that concerns the Ethics Commission. There is a way to get a contract exemption from the commission that would allow the contract to go forward. And I have an example for you higher education people. Way back in 2015, the Ethics Commission granted an exemption to the West Virginia School of Osteopathic Medicine. In this case, it bought property from the president. The president owned an adjacent lot, a lot adjacent to the university. The university wanted to buy it for student housing. Typically, that would be a prohibited contract because presidents have influence and control over all the university contracts. But the university came to the commission and said, we really need that property. It's unique. There's an overriding public benefit to us having it as a university because of its location. And the Ethics Commission granted the exemption. All right, next is the voting restrictions. Sometimes a contract can be, is permissible, but there is still a conflict. And this is the voting rule that comes into play, and it says that public officials may not vote if they or an immediate family member or their business has a financial interest. So even if they don't personally have a financial interest, there may be other people that they're associated with that has a financial interest, and therefore they have to recuse. And this is what a proper recusal looks like. And I'll let you take a look at that. I'm going to take 1 second and take a look at the questions, make sure I haven't missed anything, because we are getting close to the end of the ethics portion. But I do want to mention a few other things. There are some employment prohibitions in the Ethics Act. These apply only to full-time public employees. And long story short, these employees can't work for people in their spare time, on their private time. They can't work for people that they regulate in their public job or vendors that they oversee. So if you have any questions about that, again, go to our website or give us a call or an email. And there are post-employment restrictions, and these don't come into play too much, but once in a while we'll get a question about them. And the first is that a former public servant may not represent a client before her agency when the employee had a personal and substantial participation on behalf of the agency when that person worked for the agency. So the public employee basically can't turn around and represent the other side. And also, in particular, to staff attorneys and accountants and professional employees, they can't, if they represented a government agency in a particular matter, they can't even represent the other side in a tribunal outside of their agency unless the agency consents. And I know that's a mouthful, but we have a lot to cover. So I'm just trying to give you some highlights. So it's, when you run across these issues, you know to look for more information. And this is the other post-employment restriction. It's the revolving door. And it says that public, elected or appointed public officials and full-time staff attorneys and full-time accountants can't come back to their agency and represent clients in certain matters. And they can't do that for 1 year. The other provision I mentioned just before the revolving door is a permanent bar, and that applies when a public official worked on a particular matter concerning a particular person. So that's a lifetime bar. But if it's just a general matter and the attorney, for example, wants to come back and represent clients, that is only a prohibition for only a year. Okay, financial disclosure statements. We are just about finished with the Ethics Act portion of this presentation. So if anyone wants to pop in a question on the chat, this would be a good time to do that about the Ethics Act. Then we're going to spend about 10 minutes on the Open Meetings Act. And then after that, we'll turn off the recording, we'll turn off the mute, and anyone who wants to talk can talk freely at that point. Financial disclosures. Certain people have to file financial disclosures with the Ethics Commission every year by February 1. And these are the people that need to do so. Elected state and county officials, school superintendents, members of state boards and commissions that are appointed by our governor. And 3, certain state employees that hold the offices listed there in subcategory 3, or hold the employment rather. So for example, I am a director, a state director, so I have to file financial disclosures by February 1 of every year. Just a couple other disclosures to mention. If you are a state agency that has contracts worth $1 million or more, those need to be reported with our office, and you can find the form for doing that on our website. Same with lobbying contracts. Lobbying contracts of any value need to be disclosed and reported with the Ethics Commission. And finally, this is the slide on sanctions. These are the penalties that may be imposed for violations of the Ethics Act. I mentioned already a public reprimand. We've got a $5,000 cap on fines for violations of the Act, and restitution's a possibility as a sanction for violations. And that's just a reminder to please visit our website or contact us any way you can. I'm going to look at the chat real quick. And the question is, can this presentation be shared with us afterwards? You will find this presentation on our website by the end of the week. And I did share the PowerPoint, or slides rather, here on the group, so you may see that there separately if you prefer. And I see John Roush answered that. Thank you, John Roush. Okay, we're going to go to the Open Meetings Act because I don't see any comments or questions in the chat. The Open Meetings Act applies at all levels of government in the state. So state, county, municipal, administrative, all of these bodies should be following the Open Meetings Act. Now, the topics we're going to go over in the next 7 or 8 minutes, I'm going to highlight. So if you are someone who's responsible in your agency for agendas or setting meetings or deciding when or if you need to follow the Act, please dig deeper so you're doing everything correctly. But for the highlights, first thing to consider is whether the particular gathering is one that has to follow the Open Meetings Act requirements. Another is what notice is required and what your agenda should look like. along with the minutes, and how to handle violations. Meetings that need to follow the rules of the Open Meetings Act are when a quorum of a governing body gets together in order to make or deliberate toward a matter that requires official action. So there are 3 prongs. Now, meetings that are not subject to the Open Meetings Act are when a public body gets together just to set logistical matters, creating an agenda, for example, taking up adjudicatory matters. Those things are not subject to the Open Meetings Act. On-site inspections. It's okay for the whole city council to go together on a bus to go look at a ball field in another city to get ideas for its own ball field. There are restrictions even on these types, in these types of situations. The governing body should not be deliberating behind closed doors. Some more exceptions, trainings. If there's a group of you, a full governing body or a quorum of a governing body sitting at a table here together, and you're watching me in this training, it's okay, because this did not need to happen in public. It's not something that's covered by the Open Meetings Act. A couple years ago, after COVID died down and everyone was heading back to the office and starting to have their meetings in person again, somebody asked this question, and I think it bears repeating, because I think it's really important to know that the Act does not require a governing body to provide a physical meeting space for its meetings. All that the Act requires is that citizens be given access to a meeting to hear what's going on. So that meeting can be by telephone, conference, streaming, any other way. The requirements are that the public be able to hear what the governing board members are saying, and that the governing board members can hear what each other is saying. Notice, public meetings do need to be noticed, and in the notice there has to be the date, time, and place of the meeting. And if you're doing a virtual meeting, you need to provide, or you should provide, links to the meeting. A lot of times governing bodies these days will do both. They will, in their notice, they'll provide a link for people that want to attend virtually, and also physical address where people can attend in person. That's how the Ethics Commission handles its meetings. And the question becomes sometimes, how much notice is needed for your agenda? And typically it's going to be 3 days. And typically a special meeting requires only 2 days. And for state agencies, however, the notice needs to be given to the state secretary's office 5 days in advance. Now that's only for state agencies like the Ethics Act, like the Ethics Commission. There's an exception to all of this notice for emergency meetings. And the rule for emergency meetings is that they may be had as soon as practical, without notice, except what is reasonably practical in light of the emergency to provide. Now, an emergency is not any old little thing. It's not any old inconvenience or missing a deadline. It has to be a true emergency, an imminent threat to health, safety, property, things like that. Agendas, what you need to know about agendas is that they need to be reasonably specific. So vague headings, old business, new business, personnel, that does not satisfy the Open Meetings Act. They need to be more specific. Personnel, you can have a heading that says personnel, but underneath you have to be specific and say what kind of personnel issue is being taken up. So for example, hiring new executive director for the Ethics Commission. That's a nice specific item on an agenda rather than merely personnel matter. And you want to be sure that you're not taking up matters that are not on the agenda. If something comes up in discussion that does require official action by the governing body, then it should be held over until a time where proper notice and an agenda can be done. Executive sessions, there of course is room for executive sessions in the Open Meetings Act, but they are only for certain reasons. So make sure if you plan to go into executive session, you research ahead of time what the grounds might be, and then move forward from there. And these are some of the executive session justifications: personnel matters involving a particular employee or official. So back to the example of hiring me, the agenda item should be specific that that they are looking for or considering a hire for the executive director position at the commission. But I would expect, the commission would expect that someone, a commissioner, is going to make a motion to go into executive session based on this justification. Another recent opinion that came out of our Open Meetings Committee said that a county commission or any public body can meet in executive session with its attorney to discuss legal matters that are not limited to pending litigation. So it's okay to have your attorney, to talk to your agency attorney about policies that might have, you know, legal implications, or your attorney might advise the governing body on the legal necessity of having such a policy. Those things are okay under the Open Meetings Act. But one thing to keep in mind, when you do go into executive session, you need to come out of executive session. And at that time, a member of a governing body can make a motion to adopt or reject or whatever it is was discussed in executive session. And that needs to take place, that part needs to take place in public, and that part needs to be recorded in the minutes. And finally, we're rounding out the discussion. We have only one or two more slides here. The requirements for the minutes are specifically laid out in the Open Meetings Act. It's not a lot. It's pretty bare bones as to what needs to be in the minutes, but just make sure what needs to be is in fact in the minutes. All right, this is the final slide on the Open Meetings Act, and this is the slide that tells you what could happen when there is a violation of the Open Meetings Act. What concerns the Ethics Commission mostly is the fact that there is no enforcement authority here at the Ethics Commission. So if there is a violation, that needs to be taken up in circuit court. All right, so John, if you would turn off the recording and unmute everyone, this is the time